Good afternoon, everyone. Hope you're having a good day today. The first session we've got today on this exciting, innovative new project that we've got called The Raw is entitled Know Your Rights. The presenters on the panel, we have Juliet Spender that will be covering traffic stops, section 60, and how to make a complaint. Next up, we'll have Benson Egwuonwu, who will be focusing on personal data and how to get your information from the police. And third up, we'll have John Pegram from COPWATCH, who will be talking about how to support someone during and after a stop and search encounter. So without further ado, the first up will be Juliet.
So why a talk about rights in an event about well-being? The idea comes from, there's a power in knowledge and knowing what your rights are, and that knowledge can be applied in these ways. So you can be more prepared before a stop and search, just in case you are stopped and searched, you've got that knowledge to apply. You can have a better understanding of what is happening to you during a stop and search. You can process what's happened to you after a stop and search, if you can, better understand what rules have been applied and why. And also you can better take action to address anything that might have gone wrong. So any breach of your rights that might have occurred during a stop and search. So stop and search actually refers to a set of different powers which are similar but come from different sources that the police can apply. And the police have a lot of other powers, so to search people's homes without warrants, to arrest and to seize property, but I'll just be covering these powers on the slide, and they're powers that apply when someone's out and about in a public place on foot or in a vehicle. So the first is the power to conduct a drug search, to search for drugs. The next is a similar power, but to search for weapons or stolen items or other items, which I'll cover. The third is a power called Section 60, which is a slightly different power with a slightly different set of rules. The next is a power to search to prevent acts of terrorism. And finally, I'll cover traffic stop. And then I'll briefly also cover how you make a complaint against the police and why you should make one. The first powers that I'll cover are these classic stop and search powers. And I call them classic because they're the most commonly used, and because the test that a police officer has to meet to use these powers is typical of police powers, and I'll go through that in the subsequent slides. But the first of the powers is the power to conduct a drug search. It comes from a piece of law called Section 23 of the Misuse of Drugs Act, and it's only a power to stop and search someone for controlled drugs. The second power under Section 1 of PACE, or Police and Criminal Evidence Act, is the power to search for a wider range of objects, which are weapons, knives being the typical example, and then any items intended or made or designed for use for certain crimes. So these are theft, burglary, fraud, and criminal damage. So it could be paint canisters or even tools if the police can justify why they think they're going to be used in a certain way to break in, enter. Section 1 also covers searches for stolen items. So the list is slightly longer, but it's still limited. So if the police can't explain what one of these items they are looking for or what kind of item they're looking for, then there's a good chance that the search is unlawful. And I mentioned before that both of these powers have a test that officers need to fulfill before they can use them, and it's a test that's typical in police law. So I've highlighted it here, the magic words of reasonable grounds to suspect. And there's also a phrase which means the same thing, which is reasonable suspicion. So what is reasonable suspicion? What is this test that they have to meet? Suspicion's the mental state the officer needs to have to use the power, and a suspicion that someone has either drugs on them to conduct a drug search or has one of those items that I was talking about, so weapons, stolen items, or items intended or adapted to be used for a particular offence. And suspicions are very low test. So how often do we have suspicions that don't actually come true? And the police's job is to have suspicions. So how often, must they have suspicions that actually don't materialize? And all the protection you have and all the rights you have come from the second word of the test, which is reasonable. So the suspicion has to be based on accurate and current intelligence or information. And that can be information received by the police from another party, like an informant or a bystander who's witnessed a crime, or they can be from observations by the police, so in surveillance, or where the police have been out on patrol and say they've seen something, but there has to be some kind of objective information that they're basing their suspicion on. And that's the only protection you have really from unfair or arbitrary or discriminatory stop and search. So what is reasonable suspicion not? I think that's often an easier way to explain the concept. And we see a lot of examples of reasons that police give that don't amount to reasonable suspicion. So it can never be reasonable suspicion to stop and search someone just purely based on how they look or how they dress, unless that matches the description of a suspect that the police have received. And then some examples of reasons that officers might give that don't meet the reasonable suspicion test are smell of cannabis alone. There's been cases which say that that's not enough for a suspicion to be reasonable. Where someone's just acting suspiciously according to the officer is not enough. There needs to be some kind of more detailed reasons about what the suspicion has come from, what exactly they're doing and how they're acting that's caused that suspicion. And being in a crime hotspot as well is not the basis for reasonable suspicion, because it doesn't relate to the individual who's actually being stopped and how they've acted. And crucially, the whole sort of essence of reasonable suspicion is that random stop and search is not allowed under these powers. However, there are some powers which do allow random stop and search without reasonable suspicion. And the main one of these comes from a piece of law called Section 60 of the Criminal Justice and Public Order Act. And it allows a senior officer to put in place an authorization for 24 to 48 hours maximum, only in a certain area. And then anyone in that area at that time can be stopped and searched without reasons being provided. But even though reasons aren't needed, this still doesn't mean that the officers can discriminate. So if everyone stopped in the area under that authorization was black, that would still present a good case for saying that this power has been abused, because there's no police power that can authorize discrimination. And I'll just briefly mention there's a similar power to stop and search without reasonable suspicion to prevent acts of terrorism. Again, it would have to be authorized by a senior officer, and the power can only be in place for a limited time and in a certain area. But again, nothing in any of these powers can permit discrimination. So if you do feel you've been discriminated against, then there's a case for saying that these powers have been abused. So that covers the main stop and search powers that arise and when an officer can use them. So once they are using a power, what should happen? So the police use this memory word, go wisely, to memorize and summarize the things they're supposed to do during a stop and search. So G is for grounds, and this can either be the reasons because a reasonable suspicion is needed, or the fact that a Section 60 type authorization is in place. O is for the object they're looking for. W is for warrants that they need to show, or if they're in uniform, then that stands as proof that they're a police officer. So warrant is essentially proof that the person who's stopping and searching you is actually a police officer. I is for the officer's identity or their name. S is for their station. E is entitlement to the search record. And I'd say this is probably the most important element. And if you remember any one of these things, it would be E. And often I remember it as E for evidence, because that's what the search record is. It's evidence of what's happened. L is the legal power being used. And it should be one of the ones, hopefully, that I've covered. And Y is the fact that you are being detained. So this tells you that you're being detained and it's not voluntary and you cannot leave. So I'll just leave this slide up for a little bit longer so that you can see what I've just been through, and I'll go on. So why is the search record the most important part of Go Wisely? Firstly, it should contain all the other information from that list. So the information about, who is searching you and the reasons and what they were looking for. Secondly, it's also valuable evidence of what's happened, and without it, the officer might tell you verbally all the reasons for the search and you might remember it perfectly, but then later the officer has a different account of the reasons for the stop and search, and it's going to be your word against theirs. So unless someone's filmed the encounter, the search record will be the only evidence that you have of what's happened and why. And it's also quite strong evidence because it was created at the time of the events of the stop and search. And so, the chance of people's memories being different to what actually happened is reduced because it's produced there and then while things are happening. And once you request the search record, you might be provided with either a paper copy or information on how you can get an electronic copy later. So this is the last police power I'll cover, traffic stops. And it's not strictly a stop and search power, but because it often gets confused with one, it's worth including. So if you're in a car or other vehicle or on a bicycle, you're required to stop on request by a uniformed police or traffic officer. And someone driving a motor vehicle, even if it's stationary, so if you've pulled in, they must provide their own name and address and the name and address of the vehicle's owner and provide insurance documents. And because it's not a stop and search power, there's no requirement for grounds or an authorization or reasonable suspicion, and you don't get a search record, and Go Wisely doesn't apply. And there is also crucially a requirement to provide your details, which there isn't in other powers. But because it's not a stop and search power, the power is only to stop and ask for details. And if the officer is going to search you, then they'll need to use one of the other powers, and then those rules will apply. And often we do see that this is used as a gateway to the exercise of other search powers. So you'll be stopped in a traffic stop if you're in a car and asked for your details. And then based on the interaction you have with the officer, they might then use that as grounds to search you, to say you're acting suspiciously, or they could, there was something they didn't like that was happening in the car, and then use that to search you. So what action to take? What can you do with this knowledge? So you can ask questions during the stop and search. If you remember this Go Wisely, you can ask for the grounds or the reasons for the search, what they're searching for, ask them for their warrant, ask them who they are, what station they're from. You can ask for the evidence, i.e. the search record, and you can ask for the legal power they're using and whether you're actually being detained. You can also make a complaint about anything that's gone wrong, and you can, whether you resist the use of powers is ultimately a decision for you. It's a personal choice, but there are risks in resisting, even when you believe that the exercise of the powers is unlawful. So it's likely to lead to an escalation and possible arrest and prosecution, which can cause further trauma. And also the rules on stop and search can be complex and difficult to apply in a moving situation. And the legal rules can also change over time. So you might not get it exactly right, and you might end up obstructing a lawful search and committing an offence. So making a police complaint after the fact, now we call this a legal remedy, as it's supposed to repair or address something that's gone wrong with the stop and search. And I've put some examples here about when you might be able to complain, but they usually boil down to either that the stop and search wasn't reasonable, reasons weren't given at all, or the reasons given were inadequate, or that the stop and search was discriminatory. So I was stopped because of my race or my gender. Just put some brief kind of practical things to consider when making a complaint. So there's a 12-month deadline for making a complaint, but really you want to be making it as soon as possible before the officer or other witnesses forget the events or say they've forgotten the events, you should write down your own account as soon as possible for the same reason. So before you might forget crucial details, you can then complain in any of these ways. So in person at the police station where the officer is from, by writing to the professional standards department at the police force, on the website for the IOPC, or you can go to your local MP and they can help you make a complaint, or you can contact a lawyer for serious cases. And then finally, I've just listed some other reading to take your knowledge further. The first two are police resources, so you can Google these or search them on any other browser. They contain detailed rules and guidance that the police are supposed to follow when they conduct a stop and search. And then Stopwatch also has other resources. So we're currently updating our complaints guide, which has a lot of practical tips and guidance on preparing your own complaint. There's also a YStop app that you can log a complaint with instead of going through the police. And then finally, there's a lot of material on the website that you might find useful. So that concludes my part of the session. Great.
Thank you very much. Thank you very much. Very, very insightful. Thank you for sharing that with us. Just before we go into the next session, I just want to welcome anyone that's arrived, that's just been arriving. You are tuned into the Raw Summit. This is the first session of the summit. I think we have about 17 sessions within the whole of the Raw Summit. So they're ranging from therapeutic practices as well. So we've got a good range of alternative practices to help you deal with stress and anxiety and trauma that may arise from stop and search encounters. Next up, we have Benson Egwuonwu, who will be covering personal data and how to get information from the police.
Just a second. All right, everyone. Great, thank you. And thank you, Juliet, for your presentation. The focus of this presentation is obviously on the title screen. How do you get your personal data from the police? And so what I'm going to talk about today is what personal data is, why the police process your personal data, how you can go about getting your personal data from the police, what other options do you have to enforce your data rights against the police, and circumstances in which the police can actually push back and retain your personal data for various purposes. So that's what we're going to talk about today. So why is privacy important? Pretty obvious question, but it bears thinking about in the context of this presentation. We live in a digital age. There's around 4.5 billion people using the internet today. And so our conception of what is private life, our ability or right to be left alone, our right to kind of lead our lives with autonomy has changed significantly. There's a lot more opportunities now for our personal data to be revealed to the public at large. Chances are, if you whack your name in a search engine, some information is going to come up about you. And that's the world that we live in. And there has to be ways of navigating that world safely in order to ensure that this brand new age of privacy doesn't jeopardize our right to personal safety, our right to privacy, doesn't result in us being discriminated against, etc., etc. Obviously, with the rise of technology, digital technology, is also bled into policing and our interactions with arms of the state. The police don't just write your name on a notepad and throw it away. They take your information and they save it on databases. They record interactions with body-worn videos. We have many more CCTV cameras now. There's automated facial recognition. There's a whole host of other methods in which the police can use to gather data on us as citizens, as human beings, in order to conduct law enforcement. And so we need to be aware of what the implications of that is for things like privacy, for things like our right to information. As we know, under the European Convention of Human Rights, we have a right to respect for private life. We have a right to be left alone. We have a right to develop autonomy. We have a right to our integrity. But we also know that because of the way society is, that kind of right is not absolute. there are certain circumstances in which the state can interfere with that right in order to achieve certain outcomes, like public security, public interest, like national security, like the prevention and detection of crime. But there has to be a proportionate balance. There has to be a way in which we can hold the authorities to account in terms of using our personal data and interfering with our private lives. And that's why things like data protection laws, which I'm sure you've heard about a lot in the last few years, things like the UK GDPR, it's the UK GDPR now, we've left the EU, as opposed to the GDPR, the General Data Protection Regulation, and things like the Data Protection Act 2018, which will be our focus of this presentation, which specifically deals with data processing in the law enforcement context and the intelligence services context. So that's an overview of what the lay of the land is in terms of why privacy is important, why this discussion is important in relation to police interactions. So we're on the next slide now, and this is the key of our presentation. What is personal data, you may ask? It's very simple. Personal data is any information relating to an identified or identifiable living individual. So generally speaking, your name is personal data. Your address is personal data. Your email address is personal data. An image of you is personal data. Naturally, because it applies to living individuals, personal data does not cover people who are deceased. So that wouldn't count as personal data. And so anything that can be used to identify you, a description of you, a description of what you did, is personal data. We also have special category data, which is a type of personal data that is particularly sensitive, poses particular risks when it's processed, and therefore is entitled to a high degree of protection and a high level of justification for people who are processing that data. So that includes things like your racial or ethnic origin, your political opinions, your religious or philosophical beliefs, trade union membership, genetic data, biometric data, health, your sex life, and your sexual orientation. These are examples of, special category data, as opposed to merely general personal data. Okay. So, what grounds can the police process your personal data? Well, under the Data Protection Act 2018, the police can process your personal data for law enforcement purposes. What is law enforcement purposes? These are the prevention, investigation, detection, and prosecution of criminal offences, or the execution of criminal penalties, including the safeguarding against and the prevention of threats to public security. So these are the law enforcement purposes, and naturally, this would obviously bring to mind bodies and agencies like the police, but not just the police. It could also be the parole service, it could be the Crown Prosecution Service. Any public agency that's dealing with law enforcement in this way would be covered by this definition and would therefore be processing your personal data in that context. But it doesn't mean that the police can just process your data willy-nilly. No, they have to abide by a set of principles when they're processing your personal data. And there are 6 main principles in relation to the law enforcement purposes that they have to follow. Number 1, your data has to be processed lawfully and fairly. It has to be in accordance with the law. Secondly, your data has to be collected for specified, explicit, and legitimate purposes. There must be a point for which your police is processing your personal data. They can't just collect it for no reason. Thirdly, your personal data has to be adequate, relevant, and limited to what is necessary. So they can only collect and process what they need to. They shouldn't be collecting or processing data that they don't need to process. Fourthly, your data must be accurate and up to date. So they have to keep your records accurate. There shouldn't be any factual mistakes in there. Your data has to be kept for no longer than necessary. So there obviously has to be a cutoff point after which the police can't hold or process your personal data. They can't hold on to it indefinitely. And there needs to be a criteria that they're going to have to show in order to determine how long they hold your data for. And finally, the police has to process your data in a way that ensures appropriate security. So your data has to be protected from data breaches, from being hacked, from being released in an unauthorized way to other third parties. It has to be secured, encrypted, etc., etc. Which then brings us on to our primary right that we're discussing today. How do you go about accessing your personal data? This is a very powerful right. You essentially, as an individual, you have a right to obtain information about your personal data from the police. We call this a right of access. It's also been called a subject access request. So this is you asking the police to confirm whether or not they're processing your data and then provide you certain details as to how they process that data. And you have a right to ask them about the following things that are in this list: whether or not they are processing your personal data, the personal data they hold about you and its origin, where it comes from, the purpose and legal basis for the processing of your personal data, the categories of your personal data being processed, the recipients or categories of recipients with whom your personal data has been shared, how long your personal data has been stored for, or the criteria that they use to determine this, your right to request to have your personal data rectified, i.e. corrected, erased, or have the processing of that data restricted, i.e. blocked, and also your right to complain to the Data Protection Regulator and Authority, which is the Information Commissioner's Office, or the ICO. And we're going to talk a bit more about that later. So how does one go about issuing a subject access request? How does one go about asking the police about your personal data? Well, you can issue the request verbally or in writing. Either of them counts, but for obvious reasons, it's always recommended to write to the police because it's always good to keep a paper trail. And it also minimizes the possibility that your request may be misinterpreted or even forgotten about. So it's always good to write to the relevant person in order to make that request. And generally the police has to respond without undue delay and within a month of receiving your request. Now, naturally, because it's personal data and because such things can be sensitive, the police can ask you to confirm your identity before providing information. Because obviously what they don't want to do and what they shouldn't do is release personal data to an imposter or anyone who's not entitled to have it. So you may want to think about sending a copy of your ID, your driving license, or your passport, just to confirm that you have a right to make this request. For those of you who, for example, may be parents, and you may well want to make a request on behalf of your child, you're obviously going to have to show, again, with identification, that you have authority to ask for data on your child's behalf. So that's something else to bear in mind. If you're asking for personal data on behalf of an adult, it's also important to obtain some kind of written confirmation that you're able to do that on their behalf. So it's important to kind of, get your ducks in a row before you make that request, because what can indeed happen is the police can go back to you and say, well, we can't confirm your identity, and therefore they'll use that as a means to delay complying with your request. So consider that. The information must be clearly understandable and accessible. So it has to be in a language you understand. It has to be clear. It's not for the police to be overly complicated in the way they explain your personal data, not at all. The police must provide the information free of charge, but the police can also refuse a request or charge you a reasonable fee, which is usually an administration fee, if your request is manifestly unfounded or excessive. What is a manifestly unfounded request? It's one where generally guidance shows that is a request where the subject access request is more of a disruption. It's designed to disrupt the person who you're asking the data for. It's not actually designed to generally exercise your data protection rights. It's designed to disrupt. It's designed to be abusive. It's designed to be aggressive, and therefore it's always good to, obviously watch what you write and don't give them an excuse to reject your request on that basis. In terms of your request being excessive, it's very clear. Don't make 5 requests on the same topic within a week. That's obviously excessive. You should be making 1, and if you haven't heard from them from a reasonable amount of time, then you follow up. But don't do multiple requests on the same issue, because again, that can be read as being aggressive, and that can also count against you in terms of making your request. Other things to consider when you're making a request: ensure that is addressed to the correct person. The police, if you look on the website of the relevant police force, they will usually have an email address for their data protection officer, or a place where you should be directing your inquiries about your personal data. As we've touched on before, it's always useful to keep a log of all your communications with the police, whether verbal or written. Firstly, just to keep organized on your end, and secondly, it's always good to be able to cross-reference interactions that you've had with the police in case you need to follow up on a particular request. Now, what's quite common is that police have standard forms that they are downloadable from their websites, and they may well ask you to use these forms in order to process your data protection or your personal data requests. You can if you want to, but it's also important to know that this is not compulsory. You're more than entitled to write a subject access request on your own, or use a template that's written by other people, whether it's Stopwatch, whether it's the ICO. So you don't have to use their forms. When you're writing your request, it's useful to put down specific details to help the police actually trace the data that you need. So if, for example, after a police interaction, you want to know what data the police have recorded about you, then it's useful to note down when that interaction took place, whether or not it was recorded on a device, what was the date of the interaction, around what time, what officers were involved, etc., etc. Try and add some parameters to help whoever's dealing with your data subject access request to locate the data that you want and the data that you need. And obviously, you can specify how you would like to receive your data. If you want it in hard copy, then you can ask for it in hard copy. If you want to receive it via electronic means, then ask to receive it in electronic means. But one thing I would also just ask people to consider is when you're asking for sensitive data, just make sure that you've got your security organized. So make sure that, you know, if you're asking for sensitive data by email, then you make sure that your email account is secure. If that's a concern for you, then you may want to receive it in a hard copy, but just bear that in mind when you're thinking about how you want to receive your data. All right, so you've made your request, and let's say for argument's sake that you've made your request, they've gotten back to you and they've told you about what data they have on you and what they're doing with it. What then are your options? So just to summarize, you have a right to erasure. This means you have a right to have that personal data deleted. This has also been dubbed the right to be forgotten, as far as that's possible in the digital age, because everyone has a digital footprint. In relation to what data is being held by the police, you have a right to ask them to have your personal data erased without undue delay if processing that data will breach the data protection principles. So earlier, we discussed the data protection principles, the requirement for your data to be accurate, the requirement for your data to be processed on a lawful and fair basis, the requirement for your data to not be held as longer than necessary. If you believe that your data is being processed in breach of these principles, then you can make an argument that it has to be deleted because, quite frankly, the police would not be following the rules that they're supposed to under data protection legislation. You also have a right to have your data deleted if the police has a legal obligation to erase your personal data. So whether they're obliged under a particular law or under a court order, etc., they have to delete it if they're legally obliged to do so. You also have a right to rectification, i.e. the right to have inaccurate personal data about you deleted without undue delay. So if you issue your subject access request, you get your information back and you realize that, for example, your date of birth is wrong, or there's a material error or factual error that's in the data, then you have a right to get that corrected by them. You also have a right to request that the police restrict the processing of your personal data. So instead of doing anything with it, they have to just stop using it for whatever purpose they have. But that doesn't mean that they get rid of it. That doesn't mean that they change it. They just stop using it for that particular purpose. And the police have to restrict the processing of your personal data in the law enforcement context in the following circumstances. So where they would otherwise be required to erase or rectify your personal data, but they actually still have to hold on to your data for the purpose of evidence, in which case they have to restrict the processing. You may also have a situation in which you contest the accuracy of your personal data, but actually it's not actually certain what the accuracy is. And in that context, then the police can't erase or rectify the data, but they have to restrict its processing. So you have to stop doing anything with it for the foreseeable. And similar to a subject access request, the police has a month to comply with your request for erasure, rectification, or restriction. But what can the police say in response to your subject access request or any other request to exercise your data rights? It's well within the police to limit your rights or refuse to comply with your rights if it is necessary and proportionate to avoid obstruction in official inquiry, investigation, or procedure, avoid prejudice in the prevention, detection, investigation, and prosecution of criminal offences or the execution of criminal penalties, protect public security, protect national security, protect the rights and freedoms of others. So these are specified objectives that they can, use to limit the way in which they respond to your subject access request, or limit the information that they provide to you in response to your subject access request or any other request for erasure or restriction. Obviously, it's important to know that it has to be on a necessary and proportionate basis. It's not for the police to, on a blanket basis, refuse to comply. No. You may have a situation in which, for example, if the police is carrying out an active investigation into a criminal offense, then the likelihood is internal investigation files, any evidence that they've gathered in pursuance of that investigation would not be disclosable, because to do so would be to just jeopardize the process of that investigation. But if they have information on you that, for example, is already in the public domain, or information that you may well have already given to them, that doesn't jeopardize the investigation, then they have to give it to you. They can't do it on a blanket basis. They can't refuse a request because it's just convenient for them to do so. They have to look at the personal data on a case-by-case basis and determine whether it's necessary and proportionate to push back or to hand it to you. So that's something to bear in mind. Naturally, the police must inform you if your request for access to your data, rectification, etc. has been granted. But if they refuse a request, or if they've limited the information they provide to you under your request, then the police has to explain the reasons for refusing, as well as your right to complain to the ICO or apply to court to appeal their decision. So in circumstances in which you have a dispute with the police about what data they should or shouldn't be given to you, if you've exhausted that line of inquiry, then you may want to take your case to the regulator. You can complain to the regulator, and the regulator will use their powers to investigate and assess whether or not the police have actually made the right call legally, whether they were lawfully entitled to withhold aspects of your data from you. And obviously, if that doesn't work out in your favor, then as a matter of last resort, you can apply to court to appeal their decision. But it goes without saying that applying to court is a last resort. It is resource intensive, it is time consuming, and it definitely is a matter in which you would benefit greatly from professional legal advice. So in the first instance, it's always good to try and exhaust your options at the local level with the police, then with the regulator, and then as a matter of last resort, get legal advice in terms of going to court. If the police has restricted your rights of access, erasure, rectification, or restriction of processing your personal data, then it has to inform you that your rights have been restricted, why your rights have been restricted, and as we just covered, your right to complain to the regulator and your right to apply to court to appeal the decision. However, the police does not need to inform you that your rights have been restricted. Neither do they have to inform you about the reasons for restricting your rights, if that would undermine the purpose of imposing those restrictions. So like we just said, if there's a situation in which you or anyone else is under active investigation, the police may well not want to tip you off that you're under active investigation by letting you know that your rights have been restricted. So that's a circumstance in which they could potentially not tell you that your rights have been restricted. But again, you always have the right to complain to the ICO and apply to court. And that mainly concludes the presentation. In terms of further reading, is the Information Commissioner's Office is a great mine of information, because it's essentially their official guidance on how to interpret data protection laws and the obligations of data controllers, people who basically determine how your personal data is processed. So it's always useful to check that out. Obviously, you have the key bits of legislation, which is the Data Protection Act 2018, which deals with law enforcement processing, and also the GDPR, which deals with the processing of personal data on a more general basis. And it's also good to look at the websites of police forces, whatever police force is relevant to you, and look at what their policies are and how you can get in touch with their data protection officer if you need to make a request. I think we're doing Q&As later, but apart from that, that concludes my presentation, and thank you very much.
Wicked, Benson, thank you. Thank you so much for that insightful presentation around personal data. I hope everyone's feeling fresh and good, energized. I hope the energy's still up. Next up, we have John, and John will be covering stop and search, how to support someone during a stop and search encounter. Like I say, keep the questions coming. I can see there's a few questions in there. Do keep them coming, and we'll cover the questions as soon as John's finished his presentation. Over to you, mate, whenever you're ready, okay?
Cool, great. Thanks for the introduction, Neil. Nice to speak to everybody, or nice to see everybody even this morning. My name's John. I'm the founding member of BRISTOL COPWATCH. I've been a community activist for some time now. Basically, I've been involved in anti-racist campaigning for many years. I've had personal sort of encounters with the police over sort of demonstrations and stuff over the years. But other than that, I've been through the grind, if you will, with stop and search in my youth with Hampshire Police. I've been stopped around 53 or 54 times, a few times by even Somerset Police. Obviously, I'm in Bristol these days. And one of the reasons why I set up BRISTOL COPWATCH, we're a small team, but we're a community project as well. One of the reasons why I set up COPWATCH basically with other people, of course, is because of my own experiences with the police over the years. And obviously what we want to be able to do is help people hold the police to account as a monitoring group. We can get legal support in place. We can raise complaints to people. There's quite a lot we have under the hood, if that makes sense. But fundamentally, what we are is a fiercely independent monitoring group. And again, you know, we're here for the community. And we've been established since the beginning of 2020, so we're just over a year old now. So I guess in comparison to organisations like STOPWATCH and Netpol, we're still quite young, but you know, hopefully we're going to be around for many years to come. But anyway, just moving on to my presentation today. One of the key areas of focus for us as we develop our capacity is monitoring the police on the street. So the way, excuse me, I'm sorry. The way we work basically, other than providing support basically with complaints and helping people, you know, take action against the police or whatever it may be, is we also again monitor the police on the street, and that's similar to how the COPWATCHs over in the US in particular, and some in Europe operate as well. One of the main areas of focus, of course, for us is stop and search. In terms of stop and search in 2021, what does that look like? Well, what we've seen is an expansion of stop and search powers over the past, you know, few years, basically. Within Avon and Somerset, I think STOPWATCH actually reported in 2020 that Section 60 is back in use. And from our personal experience, with some of the work we do in the community and the outreach work we do, we discovered that there's a lot of use of Section 60 powers around the city centre in Bristol. And in general, it's a power that is used almost as a threat. I mean, I myself have been stopped recently by Evans Somerset Police, basically under a Section 24 notice. And then because I wouldn't give my name and address, I was told, unless you provide your name and address, I'm going to search you for drugs and weapons. And that's exactly what the officer said to me. So we know of other people this has happened to as well. And it seems that the police here are very keen to use powers like that almost as a threat and as a way to intimidate people that they have issues with. I've been unfortunate enough myself to be targeted by the police for some time due to my work in the community, and of course, you know, I've been through Millwall stop and search in the past, so I understand, and as a group we kind of understand, you know, how the police operate sometimes when it comes to harassment and targeting people under these powers. But as the year progresses and as we come towards the end of 2021, we're going to see more than likely an increase in Section 60, more than likely more stops under pace, and we're also going to see the introduction of SVRO, obviously, which is Serious Violence Reduction Orders, which is another suspicionless power, and isn't something that's going to bode well for many communities, black and brown communities across the UK. One of the consequences of the bill that's coming in. So stop and search, you know, as a whole, is probably one of the most used and most controversial, most criticised police powers. There is a lot of concern, and there has been over the years, that the police stop and search powers are used incorrectly or unfairly, and people often feel like they've been stopped for no reason and they're not sure of their rights. So again, going back to what I said a moment ago, there's two kinds of stop and search. You have suspicion-based stop and search, which is PACE, and then you've got suspicionless stop and search, of course, which is section 60, and it's now going to be the SVRO as well when that comes into play. I think it's being trialled at the moment. So PACE basically is, as I'm sure many of you know, PACE is basically the Police and Criminal Evidence Act 1984. It's a suspicion-based stop and search power. And if the police suspect you're carrying drugs, weapons, stolen property, or something you can be used for crime, you know, they feel can be used for crime, then they've got grounds to search you. But it must be based on reasonable grounds. So you can't be stopped for no reason. You can't be stopped because of your physical appearance, whether that be, you know, your ethnicity, your gender, whatever it may be. You can't be stopped as well for having a criminal record. Now, obviously, there's what the law says the police aren't meant to do, and there's what the police actually go out and do. So in my own personal experience, I don't mean to talk about me all the time, but in terms of what I've been through stop and search, I understand, you know, again, how this works. Basically, you cannot be stopped for having a criminal record. Well, okay, you can, and police will often do that. And for a while, when I lived in Hampshire, I was stopped quite regularly by the same police officers, because they would say to me, "You're a known drug user, you're walking in this area, you used to have an issue with drugs, you know, it's, as you say, you're in an area where we suspect this is happening," or it would be you're fitting a description. And even before the point I actually got in any trouble with the police, basically, before I broke any law as such, I was being stopped from the age of 16 years old, and I was being racially profiled. And I think that was something that consistently happened after I was stopped and asked whether or not I had been in a certain area, because there'd been some burglaries, and the guy that had been stopped was mixed race. What they were looking for was mixed race. I was inconsistently stopped for riding a bike on the pavement and this kind of stuff. And it was primarily based on racial profiling. It was a generic, "It's a short bike" kind of thing. "Where did you get the bike from, son? What are you doing down this road?" And then obviously, as I went further into the criminal justice system, things unfortunately developed and changed. So again, going back to what I said a moment ago, you know, we are kind of aware that what we're told about, you know, PACE, what we're told about stop and search powers isn't always how it actually plays out on the street. I think that's really important to understand as well. So then we move on to suspicionless stop and search. Okay, so we have section 60 of the Criminal Justice and Public Order Act 1994. That basically allows a police officer to stop and search a person without suspicion. Police just don't need to have any reasonable ground to stop and search you at all. Again, you fit a description, you know, you're walking down the wrong road, I don't like the fact you've got a hoodie on, that kind of stuff is used for section 60, basically. Section 60 can only take place as well if authorised by a senior officer, and the authorisation will last 24 hours. And police generally should explain why section 60 is in use. So if you look at the textbook reasons, it will usually be because there may have been violent crime in the area and they're looking for somebody they feel may have a weapon on them, or it may be sort of violent disorder is anticipated. So that's when the police will usually roll out section 60 powers. So we see that happen in areas like, you know, like Tottenham, like Haringey. When something happens, the police sort of decide to unleash those powers. But also, you know, again, you know, we see officers choose to use that power as a reason to stop somebody they may have an issue with. So from my point of view, and I'm sure many of you feel the same, it kind of opens the door to disproportionate and potentially pretty racist policing. Again, you should really be treated fairly under the Equalities Act of 2010. If you're somebody with a protected characteristic, the police shouldn't use that as a way to, as a stick to beat you with. But obviously that, you know, isn't always the way it plays out. And you're entitled to a written statement as well if you're stopped under section 60 if you apply within a year. So what does bystanding and stop and search look like? Okay, so this is basically what a part of what cop watching is, or, you know, I guess filming the police is basically. Sometimes when you witness an incident with the police, some people, you'll notice people gathering around to film what's happening, okay? If you're going out specifically to COPWATCH, maybe with a couple of friends, and you know there's some people who are just being stopped and searched for no reason, almost in an area, bystander intervention is kind of key to what we do, basically. So say I was on the street and I saw somebody being stopped and searched, and I thought to myself, they don't look very happy, I would want to check in with that person and make sure they're okay and see if I could find out what was going on. It's basically an indirect approach to de-escalation of a situation. I've been in the situation before where I've de-escalated it to the point where I've actually got that person de-arrested. That doesn't make me a hero. It's just that I listened to what was going on, and the person I was trying to support had mental health issues, and the police actually acknowledged that, took the handcuffs off, and they let them go. And it's very rare that kind of stuff happens, but it does happen. It's kind of liberating in a way when it does. But again, it's really an indirect approach to de-escalation of the situation. The first thing really you should be doing is checking in with the person that's being stopped and searched. So if you see somebody there's got a few cops around them, they don't look very happy, the best thing to do is just say, "Hey, you okay?" That's what I've said in the past is, you know, "How you doing? You know, are you all right?" kind of thing. And usually you'll get some sort of response, even if it's a head shake or if it's just a yeah kind of thing, then you know that person is or isn't okay. If you are going to film as well, and it's usually advisable that you do, just make sure the person being stopped is happy for you to film or document what's happening. You may not have a camera with you or a phone with a camera that works. So if you've got a pen and paper, so in your lunch break from work, then maybe you can jot down what's happening. You know, in particular, if it's particularly violent stop and search and you just don't like what you're seeing. But just make sure if you are going to film, yeah, that the person basically on the receiving end of the police, if you will, ideally is happy. I know sometimes it's not always that easy. What I've said before again is, do you want me to film? And people either say, yeah, film please, or no, don't, you know? And it's always worth, because you're looking out for that person's well-being, just respecting what they've said. Just be firm as well, clear and concise if you are challenged by the police, and it will happen. If you're filming the police when there's a stop and search happening, the common response is, you're obstructing us. If you continue to obstruct us, you're going to be arrested. Just make sure, you know, that you are at a decent distance from the police. You aren't getting in the way of what they're doing, and you are focusing your camera on them and not the person in question, so you don't make the person in question worried about what's going on. Because another one may be, they may try and throw a Section 5 warning at you. They've done that to us before, basically, when we've been filming them. And they've said you're causing distress to the person that we're trying to deal with. If you continue to cause distress, even though we weren't saying anything at all, I wasn't saying a word to the person in question, you're going to be arrested for breach of police, basically, and then it's obstruction, that kind of stuff. But you just need to be firm and clear and concise and just say, officer, I'm within, you know, a reasonable distance. I'm not in your way. I'm not obstructing you from doing your job. I just want to make sure the person you're dealing with is okay. Yeah, and I'm just filming you and not them. And that's how I've acted before. And usually if you show a degree of confidence, I'm not saying necessarily the police will back down, but what I'm saying is they will obviously take you slightly more, slightly more in respect to somebody there who's concerned for someone rather than someone there who's there to cause trouble, you know, or raise hell. So again, if it's safe to do so, just film or document the incident. And don't be afraid to ask passerbys for support. So usually what we see in Bristol is one person starts filming, someone else walks past, especially in areas, you know, like say St Paul's or maybe Easton. There's a lot of stop and searches. One person starts filming, another person starts filming, and then people say, what's going on over there? And then you have people, you know, just generally making sure the person on the sharp end of the cops is okay. But that's what Bristol's like. It's the same as a lot of places. There's a real sense of community in these kind of areas. You know, we love it. So asking a passerby, you know, just for support is always worth doing. Just say, excuse me, do you mind filming this as well? Especially if you think the police may start targeting you because you're filming what's happening. So here's just a few do's and don'ts, just following on from the last slides. When you're bystanding, or kind of, you know, when you'll be at bystanding stop and search, just remember to record names and record badge numbers of officers, and ideally find out what station they're from. Always check in with the person, as I mentioned before, who's being stopped and searched. Stay nearby and stay present, but don't obstruct the police. It's something that we always reiterate, just don't obstruct them, because that's what they're looking for, is a reason to arrest you, basically, because the police in general don't like being filmed. And just stay focused on what's happening, and ideally stay calm. If you can as well, just let somebody know where you are, especially if you're not with a friend. There are secure messaging apps out there that I would recommend, that are Signal, and then there's another great one called Silent Phone. If you're going out as a small group and cop watching, maybe it's worth just making sure you're messaging each other on Signal, just so you all know each other's okay, and especially if there's a violent arrest that you're witnessing or a violent stop and search, it's worth checking in with somebody so they can say, okay, you know, whoever it may be was with, you know, was witnessing the stop and search, and they were trying to film it, and then obviously we can, you know, people can come and support you if needs be, or come and support the person in question. So just moving on to my next slide, just a brief couple of points on how to film the police. When you are filming the police, just keep the camera focused on the cops and not the person. Video evidence of police assault or misuse of power is invaluable, and keep your camera horizontal, not vertical, just like in the photo there. Yeah. So if you keep your camera horizontal, not vertical, you're going to get everything in the scene, if you will. So you make sure you're focusing on all the officers, even if they aren't directly interacting with the person. You can see what all the cops are doing and what's going on. And again, going back to what I mentioned a moment ago, video evidence of a police assault or misuse of power is absolutely invaluable, because the body cameras we see them wearing here, that will usually, we're meant to have the lights on, basically, aren't for our protection, they're for the cops' protection. If you've ever been through with the police and you've asked for body camera footage, I think it's up to 30 days. You've got to get the footage or delete the footage altogether. Okay, so if you have your own video evidence or even photographs with documented accounts with witnesses, that's going to take, you know, that's going to serve invaluable. That's going to be invaluable even if you need to take further action against the police. So what happens after the stop and search and after you witness what's happened, what's going on as a bystander? So a stop and search may lead into an arrest. A stop and search may also become increasingly violent with aggressive police. If you carry a bus card, just try and get it to the arrestee or the person being stopped. GBC, Green and Black Cross, release bus cards. We're going to get our own bus cards made up soon. It's advisable sometimes just to be mindful about the police and how they're acting. I've been in a situation when I've witnessed an arrest basically of a homeless person. I tried to give that person a bus card, and the police officer was accused me of trying to pass drugs to that person. And I said, look, I've got a bit of card in my hand. But as soon as that happens, they see it as a reason to make another arrest, a reason just to get you out of the picture and out of the way. And again, just do be mindful that if you stop and search or become sort of increasingly aggressive and violent, it's worth just keeping a kind of a safe distance as well. Offer as well, all being well, if things kind of calm down to a point when you can talk to the person directly, just offer to send the person your video that you've recorded. Pass on our details if you're in Bristol, maybe in Somerset. All the contact details from monitoring groups such as Stopwatch or Netpol or anybody else like that, if that person wants them, of course. And just find out if they are arrested, ideally where that person is being taken to, and ask if there's anyone, you know, they want that they want you to contact for them. And also, just finally, just be mindful as well, just about sharing videos on social media. I think one of the most common things that was happening last year when there was a, you know, sort of the incident with George Floyd and everything else, it's all around the world. There was a lot of demonstrations and there was a lot of focus on the police and how they're acting. There was a lot of video shared on social media. It's worth remembering the trauma that videos sometimes of police brutality and even just a, you know, a bad stop and search can cause. So I would be very careful about what you share on social media. I mean, sometimes you may be in a situation where somebody's saying keep filming, share the video, tell people, okay, that's fair enough. How you decide to deal with that is down to you, but also do be kind of aware again of the, you know, the trauma that the videos or sort of police brutalities I said can create too. So just as my final slide, I just wanted to run over a couple of points on de-escalation versus escalation. So going back to the actual stop and search in itself, as I mentioned a couple of times now, just don't give the police a reason to arrest you. Don't give them that reason, and they will try and find it. It may be Section 5, it may be obstruction, it may be anything else, basically. Just try to avoid antagonising officers as well, and don't be afraid to challenge them. So what do I mean by that? Well, the stop and search in general, like situations involving the police, emotions can be running high, right? So I've seen situations where people have been swearing and shouting at the cops. That really isn't a good thing. It's not always difficult when things are kicking off, if you will, to stay calm, but just stay calm. And obviously, if it's a slightly more kind of like, standard kind of by the book incident, I guess it's easy to stay calm. Just always sort of be aware of what's happening around you, and don't just kind of react to kind of aggressive, nasty police, because police are very good at pushing our buttons. They'll push the button and they'll see what the reaction is, and that's obviously what they're trying to do. But don't respond by antagonising them as well. But also don't be afraid to challenge them. So if you see something happening that you don't like, you can ask them again what station they're from. You can ask them for their badge numbers. Most importantly as well, you should ask them what power they're operating under too. Yeah, so it's going to be, if it's a stop and search, it's going to be pace, or it's going to be Section 60, or maybe if it's a weapon search these days, it would be the SVRO that's come into play as well. And if you are going out to COPWATCH and film the police, do try and have a buddy with you if possible. I think possibly the worst thing you can do if you decide to go out and COPWATCH is get caught up in a volatile situation and it's just literally just you, because being honest, you're more than likely going to end up being targeted. So if you're in a small group or with a friend, then you've got less chance of that happening. And as I've said already, do try to find out what power the police are operating under. And of course, most importantly, if you can, always remember to film the police, because again, video evidence, when it comes to our rights and helping people take action, for police brutality, harassment, whatever it be, is absolutely invaluable. So that's kind of a whistle-stop tour there. That's basically everything I wanted to run over. I'm sorry if I whizzed through that a little bit, but I got some of the material on Section 60 and also on pace, just from Liberty. So I just wanted to give them a little kind of head nod. Obviously, some of the slides are our own as well. But if you want to find out more about those powers, then Liberty, like STOPWATCH, organisations like Netpol are great monitoring groups to check in with. But thanks a lot for your time anyway. And over to you again, Neil.
Excellent. Thank you so much, John. We lost you on the last bit there, but I definitely got the thanks for your time. And thank you for your time, and thanks for a brilliant presentation there. Really insightful, really a lot of information in there that people can take away, even myself. So yeah, there's definitely some good points in there.